Arguing in support of the federal government and the FDA today was a coalition of 24 state attorneys general who signed on to an amicus brief urging the court to protect access to mifepristone. That ruling against expanded access could, quote, drive many individuals to undergo unwanted procedural abortions, push abortion procedures to later in pregnancy, and sharply increase risks, costs, and delays, and deprive many individuals of access to abortion care altogether. Joining us now, Attorney General for the state of California, Rob Bonta. Mr. Attorney General, thank you very much. So lay out what you were arguing in your amicus brief.
Well, thanks for having me. Honored to be here with you. And we filed an amicus brief. It had two primary arguments. One, that mifepristone is safe, has been safe for over 20 years. 5 million women have used it safely. It essentially has zero risk of death, very, very low risk of any adverse health consequences. We've also said that returning the rules to the pre-2016 FDA rules would be against the public interest. It would make mifepristone less accessible by creating more in-person visits, not allowing it to be accessible during up to 10 weeks of gestation, only having physicians be able to make prescriptions, no availability by mail for prescriptions, and no accessibility by telehealth. So those are our major arguments, and we feel that the safety argument and the public interest argument were well absorbed and understood by the court, and we're hopeful for a positive ruling based on today's oral argument.
Mifepristone has been on the market for decades. The expanded access has been around now for about 8 years. Has the state of California seen any uptick in emergencies having any relation to mifepristone?
No. It's safe. It's been safe. It's been safe for over 20 years. And, it's the most common method of abortion in the United States. It's safer than Tylenol. It's safer than a colonoscopy, safer than Viagra, safer than wisdom tooth removal. It's safe. It's been determined by study after scientific study for years and years. And making sure that those who need it have access to this safe abortion method is critical, and the FDA has seen that in its wisdom, and based on scientific evidence, based on indicia of safety, has created pathways for more availability to more people in need.
How'd you hear the arguments today? What's your sense of what might happen?
After observing the arguments, I think that there's a likelihood of a decision based on standing, that those who brought this case were not able to show the appropriate nexus between the alleged offense and their alleged injury, and that the FDA's REMS, their rulings on risk evaluation and mitigation will remain in place based on the scientific evidence that supports them, and that there could be some dissents that raise issues like the Comstock Act, but I think it will be the FDA who prevails, likely based on standing.
Do you expect to see litigation on the Comstock Act coming or going forward?
Perhaps. I think it's sort of lingered as a place where those who seek to attack what had long been, for over 50 years, a constitutional right to an abortion, those who are not satisfied with the Dobbs decision, which allows states to decide whether abortion is legal or not and want it to be banned nationally, even in the states that want it. I think it's been an area of interest for those folks. And so I think it is a potential pathway for them for additional challenge. But it's old, as it's been described. It's a zombie statute. I don't think it will carry the day. It's sort of an outside Hail Mary attempt that could be tried. But will it be tried? I would not be surprised if it were.
One of the arguments that the justices brought up is that if you do not want to perform a procedure because of religious reasons, you're allowed to. You're allowed to opt out of it. You don't have to perform that procedure. Can you explain the statute that they were talking about? Yeah,
there's an exemption based on a conscientious or a conscience accommodation already in the existing law that individuals that, based on their own conscience, don't want to participate as a physician in prescribing mifepristone don't have to. And so that was pointed out by, I think, both conservative and non-conservative judges on the court today as a clear accommodation already existing in the law. And I think that was a problem for those challenging the FDA's approval of mifepristone.
Attorney General of California, Rob Bonta, thank you very much for joining us. We appreciate it.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.